Why do domestic asset protection trusts fail? Also, this might be the reason why you don't want a domestic asset protection trust, or for that matter, a foreign asset protection trust, because they're really structured the same way. It's just a matter of is it a jurisdiction within the United States, which here we refer to as domestic asset protection trust, or a jurisdiction that's offshore that we would call a foreign asset protection trust or offshore asset protection trust. So I've watched a lot of videos on YouTube, read a lot of different blogs from a variety of different types of advisors about these asset protection trusts. And there's a lot of different material and thoughts about these, which I think is very interesting. I will comment that I see a lot of content that's produced, videos and otherwise, from people who are not attorneys. And I think that is a huge red flag and a huge problem. I don't know why they're in this industry. I don't know how they've not got sanctioned for the unlicensed practice of the law. That's another story, but I am curious about that. I think a lot of times you'll see videos and content that to me are gimmicky and salesy, and I think a lot of times they come from those kind of outfits that may not be actual law firms or be attorneys. So that's something to think through. And often you'll see them talking about how domestic asset protection trusts fail, and that's why you have to go with a foreign asset protection trust, and because only a foreign asset protection trust is really foolproof. And they'll say courts are going after domestic asset protection trusts, and they're failing, and we see them failing all the time, and we're seeing courts have claims against them, and it goes on and on and on. But there's no real substantive details that are shared about that, right? About why these DApps are no good, why you got to go with the FAP, and why they're failing. So this is what we do know, okay? We know that DApps, if done properly, will protect your assets from creditor claims. Can someone have an enforceable creditor claim against a DApp? Sure, that's possible, but that isn't necessarily always the case. But this is where DApps and FAPs, for that matter, fail. When there is a fraudulent transfer or a fraudulent conveyance to the trust. So how this even works with a DApp or a FAP, you have a client who's the settler. They're setting up the trust, self-settled trust, for the benefit of themselves. They're moving at their own assets into that trust, self-settled, self-funded, although someone else could put assets in there, and also self-benefiting. If done legitimately correct, there's no issue. The issue is when you start transferring those assets to that trust. That's where people get in trouble. That's where these things really fail. So each state that has a asset protection trust statute that allows for these, and if you watched my videos before, then you know that not every state or every jurisdiction has a self-settled, self-benefiting, irrevocable trust, right? So I'm in Texas. Texas doesn't have one. California doesn't have one. New York doesn't. Florida, some of these larger states where I see a lot of clients coming from don't have them. We do our planning in South Dakota. So South Dakota, along with every other jurisdiction that has these asset protection laws, trust laws, has a statute of limitations, right? Because they want to help clients protect their assets from creditors. They want to make this available. They see it as a good thing to give citizens the ability to protect themselves from frivolous lawsuits, especially wealthy clients, business owners, whoever it may be. But they also don't want it abused, and that is reasonable and that makes sense. That's a good policy consideration. And so the way to cut down on these issues of being abused is this fraudulent conveyance, fraudulent transfer laws that we see. And ultimately what that says is there's a statute of limitations that you have on being able to transfer assets to the DAPT or FAPT without someone bringing a claim and trying to say you fraudulently transferred those assets for purposes of defrauding a creditor, for purposes of just, like this creditor has a claim against you and you're trying to avoid it by setting this DAPT up and transferring the assets in. So typically when this happens, there's going to be an existing creditor, right? meaning they have a creditor claim against you, and you know about that, and you go ahead and you set up the DAP or the FAP and you transfer the assets over. That's usually the most common situation. There's other situations, but I'm not going to focus on all of those. We're just going to focus on this more common situation. So each jurisdiction, along with the statute of limitations, so the statute of limitations differs. South Dakota's 2 years, Nevada's 2 years. Ohio has a DAP statute, and I believe it's only 6 months, and that, I think, is the shortest of any state. I think Delaware's 4 years. Wyoming has become more popular for whatever reason as a asset protection trust jurisdiction. There's a whole lot of reasons why it is not the best jurisdiction, even though it's gaining more popularity. I don't remember what their statute of limitations is. It might be 2 years, 4 years, 5 years. I can't remember. I'm thinking it's 4 or 5. But so along with that statute of limitations that I just discussed, you also, the creditor has to prove that you fraudulently made that conveyance or that transfer. And the level of proof that they must present to the court differs from state to state. So that is something else to look at when you're thinking about which state has the best asset protection trust laws. And so in South Dakota, as well as Nevada, it's clear and convincing, which is usually the highest level, the highest standard of proof that must be presented to the court for them to claim to make the decision that there is a fraudulent conveyance that has occurred. So I won't go into all the details about what they actually have to present, or that's probably a case-by-case situation. But ultimately, you look at two things: statute of limitations, and then also what level of evidence has to be presented for the court to decide there has been a fraudulent conveyance. Point of all of this is where people get in trouble with DAPs. This is where they end up failing people because they didn't do the planning correctly, right? So if that is your situation, you have a current creditor claim against you, it's going to be very, very difficult to successfully pull together and set up a DAP. The other thing to think about with this is whether or not you have great privacy laws that are attached to the DAP laws. And that's what South Dakota really, really focuses on, or has focused on. And so what's unique about South Dakota from any other state, and other states don't have this, is let's just say there was some type of lawsuit against a trust that was set up in South Dakota. Any of the details that come out in that court proceeding have an automatic seal, and it's a perpetual seal, meaning that it will never become subject to any of the public domain. And other states don't have that. Delaware has something similar in that they give the judge discretion to be able to seal any information that comes out about a trust in a court proceeding. However, it is not a perpetual seal, and it only lasts 3 years. So people shouldn't be scared to set up DAPs when they hear, oh, they're failing, or even FAPs for that matter, because they're failing, because they're being challenged. Like, they should be challenged, right? Like, people who have claims, if they really want to try to have a claim against someone, they should be trying to track down where they have assets or where they have a trust, and they should be trying to challenge the legitimacy of a trust. Any good attorney is going to represent their client to the fullest extent possible. They would try to hunt down and figure out where this client might have set up a domestic asset protection trust. Good luck on figuring that out. I think you got to be really committed and have the manpower to be able to figure that out. But again, a good attorney would try to challenge that, but that doesn't mean anything. Just because they're being challenged doesn't mean anything. And we've seen that the creditor protection itself is working. We've seen those being challenged, and we've not, to my knowledge and other attorneys that I know, we've not seen the actual creditor protection aspect of it fail anyone. But what we do see is issues with the fraudulent conveyance, and that's where people get in trouble.